we have people joining us from Australia to India to Germany and England. Some of the registrations, some of the registrants at this point in time. So those online, again, welcome, and I'm glad we can be able to reach out not just physically, but to everyone else. Since I presume that you already know that we're here for what we call the collaborative contracting in the delivery of construction projects, for a distinguished panel as well as two very distinguished practitioners to share on the international experience. This is a joint collaboration between the Singapore Academy of Law and the Singapore International Commercial Court. And at this point in time, I'd like to say a shout out and a very sincere thank you to Squire Patent Box, who is sponsoring the networking reception after this. I'm sorry, those of you online, you don't get to enjoy it. But for those of us down here, it's, I would hope, a motivation to stay on and perhaps interact and find out more from the panel or from each other as to more about what collaborating contracting is and how it can actually work in terms of not just ensuring that we have less disputes happening, but that even if should disputes happen, how can it be an efficient and effective way to move forward and preserve business relationships. And with this one, I would start it off by asking two very renowned people to work on it. The first would be Mr. Bruce Reynolds. He's co-managing partner of Singleton, Urquhart, Reynolds, Vogel, LLP, and co-chair of the firm's International Construction Projects Group. Bruce advises clients on construction projects in Canada, United States, and overseas. In addition to his practice, he also acts as a mediator, arbitrator, and facilitator, helping to resolve construction industry disputes. Together with his colleague, Sharon Vogel, he played a significant role in helping the Ontario government modernize the province's construction law and helped to shape the Constitutional Act. Among the changes to the legislation are the creation of a prompt payment regime and the introduction of a mandatory interim binding dispute resolution system. Bruce was also retained as counsel by the federal government of Canada to assist in the introduction of new legislation on prompt payment and adjudication, co-authoring the independent expert report, Building a Federal Framework for Prompt Payment and Adjudication. Bruce has been certified as a specialist in construction law by the Law Society of Upper Canada. He's a fellow of both the Canadian and American Colleges of Construction Lawyers, and also past co-chair of the International Construction Projects Committee of the IBA. Bruce is also the current president of the IAACL, International Academy of Construction Lawyers, which met at the end of last week. Bruce has been recognized twice as Global Construction Lawyer of the Year by Who's Who Legal and as Toronto Construction Lawyer of the Year by Best Lawyers. He's listed in Chambers Global as Band 1, which is not surprising, I guess. He should be. And Martindale-Hubbell, AV, and he's also recognized in the Lexpert American Lawyer Guide to the leading 500 lawyers in Canada for construction law and the Canadian Legal Lexpert Directory. With the introduction, no, I'll do both at the same time and then I'll invite you up. And of course, working with Bruce hand in hand on the presentation that we will hear soon is Mr. Thomas P. Wilson, who's a UAE managing partner for Squire Patent Box, MEA LLP. Tom is a former member of the firm's global board and now serves as managing partner of Squire Patent Box, MEA LLP UAE offices and heads the construction and arbitration practices in the Middle East. Amongst the legal construction disputes lawyers in the region, Tom represents private and public owners, international contractors, and original equipment manufacturers in resolving disputes over the construction and operation of infrastructure assets. Tom has considerable experience in resolving disputes through arbitration and alternative dispute resolution, and serves as advocate in arbitration proceedings of all types and in the DIFC courts. Chambers Global 2019 noted that Tom is a construction lawyer through and through, who understands the Middle East very well, and in 2021, that he has a wealth of experience representing clients in significant ICC arbitrations. Who's Who Legal rates Tom as a global elite thought leader and one of the standout names in the construction market. And with those, ladies and gentlemen, I'd like you to help me invite Bruce and Tom up to talk to us about collaborative contracting. You have the clicker there.
Is this on? Yes, it is on. Thank you so much for inviting us this afternoon. We're looking forward to a wonderful dialogue on the subject of collaborative contracting. The first thing I'd like to do, however, is apologize for the length of my bio. It seems like a coral reef in good health. It has expanded over the years, and I particularly apologize to Lawrence. It seemed to take more time than it was probably entitled to. Having said that, the subject of the session today, of course, is collaborative contracting, and Tom and I have put together a slide deck, which is not too long, but hopefully will call out the critical issues that we would like to discuss with you this afternoon. I was reminded a few moments ago that when we think about the subject of collaborative contracting, we have to appreciate, and this will emerge through the discussion that Tom and I are going to lead, that it's a spectrum. At one end of the spectrum of collaborative contracting are relatively modest efforts to try and break through the DNA of adversarialism. And we just came out of a conference that was devoted entirely to the theme of whether there is a duty of collaboration which will assist the parties to construction projects to move beyond the DNA of adversarialism. At the other end of the spectrum of collaborative contracting are emerging contractual models such as IPD, and we're going to be speaking, of course, about integrated project delivery as well. So, what are the basic principles of collaborative contracting, which are fairly characterized as a class of contracts falling along that spectrum as a species of relational contracting? So, focusing on those basic principles for a moment, collaborative contracts are multi-party agreements. And so, of course, this immediately takes us outside the conventional paradigm of a stacked structure or pyramid of bilateral agreements and delivers the parties into a multilateral environment. Under these types of agreements, the parties pool the potential profits to be derived from the project and introduce a mechanism that will affect a gain share and or a pain share, depending upon the success of what is now, in essence, a project team in delivering the project. Now, one of the other key elements which appears to be consistent across the spectrum of collaborative contracts and which moves what I suppose I will again call the team away from conventional thinking is a waiver of almost all rights of litigation against one another. When we consider the word most, it's worth noting that the exception to the broadest of waivers is typically an exception with relation to willful misconduct, which in my experience would extend to reckless behavior. In the case of parties who behave toxically, notwithstanding having subscribed to this multi-party agreement, there are circumstances where reckless behavior can be encountered and rights of termination can arise. So this is not an environment without risk. It's not an environment, and we will get to that, it's not an environment that does not suffer from the typical exigencies of human nature. But it is an environment that is structured to try and contain problematic behaviors. Another fundamental feature is that the team, which includes the employer, commits to jointly managing the project on the basis of consensus. And consensus building really is based upon mutual trust, of course. And you can introduce, and the modalities of interaction that have developed around collaborative contracting are intended to promote trust building. And we'll speak a bit more about that as we proceed. Another fundamental feature of this type of agreement is that it tends to embrace modern technological approaches to the construction process, such as BIM or lean project management, focused on the diminution or avoidance of wasteful aspects that reside within the conventional structure. So the concept here is to share control, to spread and cap the risk, and share the rewards if the team is able to successfully collaborate, is able to develop the trust and the effective communication that appears to be essential to the success of these types of arrangements. As you'd appreciate, as you'll hear about further as we go through our slides, early involvement of the key participants is deemed to be essential, and there are educational workshops and team building workshops at the front end of the project that are part of this process. The next fundamental principle is the joint development and very careful checking and validation of fundamental project goals, including the development of a target cost and a time for completion. Now, there's a very interesting feature here, which will also come up again, which is that target cost is developed by the team early on in the process. And design is intended to occur within that pre-established target cost. When you consider that design follows the establishment of target cost, that raises the specter of design risk, but in this type of contract, the waiver of claim provision, combined with a provision that limits the risk of the contracting members of the team to their potential profit and leaves the owner to pay any costs beyond that, really eliminates the design risk, which can be so problematic for contractors in a conventional delivery system. And then finally, before we move to the next slide, and this may sound somewhat Pollyanna-ish, if that's a word, I may have just invented a word, co-location is considered to be a fundamental element of the success of collaborative contracting. So co-location, as you would know, is putting the entire project team, the owner team, the contractor team, the design team, the teams of the senior subtrades, together in the same physical space so that they are working side by side 24/7 right throughout the entire project. And we'll talk a bit more about some of the values that are seen to flow from co-location.
Thank you, Bruce. And thank you all for your interest in this topic and for being here with us. Bruce has set the stage by explaining what it is we're here to talk about and what, in essence, what a collaborative contract is. At this stage, what I'd like to do is put that type of contract in a bit of context. We're all lawyers, or mostly lawyers in this room. As such, we all deal with contracts on a regular basis, and we see them within a legal framework. And some of you who may not be so familiar with collaborative contracting may be wondering how it differs and why. My perspective, at least, on the development of collaborative contracting is that it has grown from a certain dissatisfaction within some segments of the engineering and construction industry with traditional modes of contracting. Design, bid, build, and design, build contracting, as the slide indicates, particularly on large, complex, and long-term projects. Now, in regard to those projects, a bit of context is as follows. We are all aware that collaboration is key to the effective delivery of virtually any, or certainly any, complicated or complex project. And we needn't and shouldn't confuse the importance of collaboration generally in the delivery of a construction project with the very specific contract frameworks that go along with these what are somewhat new methods of delivery, such as IPD, which Bruce will explain a bit later, and alliancing contracting, which are two of the better known types of collaborative contracting structures. So from my perspective, what has occurred, certainly in the oil and gas industry over time and in other large infrastructure industries, is that project participants, often owners, began to certainly implement it or sought to implement collaboration on their projects, but found that the contract structures under which they were operating were in tension with, or created tension within the teams that they sought to drive to collaborate. And there became to be a dissatisfaction, particularly on a certain risk or a certain type of project, in my view, a dissatisfaction with the misalignment between the contract structure and the desire for a need for collaboration in order to ensure effective delivery. And that dissatisfaction arises, at least in part, from the tendency, when the going gets tough, as they say, of parties to look reasonably, look after themselves and their own interests, as opposed to the interests of the project. And while as a young lawyer, I heard lots about the interests of the project and pursuing the interests of the project, but also lots of pushback from clients saying, well, the interest of the project is all well and good, but first I have to protect the interests of my pocketbook. Well, what collaborative contracting then seeks to do is align those things, align the interests of the pocketbook with the interests of the project for all of the parties, and thus curtail the adversarial behaviors that tend to arise when difficulties or unexpected circumstances are encountered on a project, and encourage parties to behave in a way that lifts the entire project, because everyone is sharing in the pain and sharing in the gain, as Bruce introduced. And some of the other ways that collaborative contracting differs from more traditional contracting structures and helps to promote the effective delivery of the project is, as Bruce noted, you have early involvement of all parties in the contract, and that enables early involvement of all parties in the design and planning process for the project, which is that's not unique to collaborative contracting structures, but the fact that everyone's profit, and in some cases overheads, are on the line with the success of the project certainly encourages parties who might not have taken so much interest in value engineering or design reviews to take a much closer and more complete interest in those at the outset of a project. And again, as Bruce has noted, the joint development and validation of the project targets and goals means that everyone has an opportunity at the outset of a project to identify each other's interests, identify the needs and interests of the project, and seek to align those from the beginning so that everyone is aware in the round of what the needs and interests of the project are. Now, Bruce will take us through some IPD discussion.
I think it's worth pausing for a moment to think about what Tom just said about collaborative development of target cost through early stage workshops, which include the employer. What this means is that the cost structure of the project and the overhead aspect of the estimate and the profit aspect of the estimate are fully transparent to the employer. And if the model is followed and this target cost is arrived at and ultimately agreed on the basis of consensus, this represents, from a conventional perspective, a very radical environment in which the owner is fully informed as to the cost structure of the contractor. I act for many contractors who are well ensconced within the conventional model, and this is probably the last information that they would give up once litigation had been commenced and court had ordered them to do so. Apart from this type of mandatory requirement, they would be very reluctant to share this type of information. So, you know, again, it's a spectrum. And so if you think, just to be brief about this, if you think about one end of the spectrum, which is the prototypical end of the spectrum, you can think about circumstances where in the midst of a project, the parties agreed to open up a without prejudice bubble and work within that bubble to solve a serious technical problem. That is opening up an opportunity for collaboration within a conventional structure. The next step up the line of the spectrum towards alliancing an IPD, arguably, I think there's a consensus on this, would be partnering. And we're all familiar with the concept of partnering. Partnering could be seen as a forebear of the types of contracts we're here to discuss today. And as I said earlier, at the other end of that spectrum is IPD. So IPD, which has gained quite a bit of traction in a number of jurisdictions, including Canada, the United States, is characterized by a number of features which are set out on this slide, and I mentioned them, some of them, not all of them, earlier. The utilization of modern technologies and approaches to project management and design. Second, the incentive compensation layer, or what I referred to earlier as the profit element of the target cost structure. And the principle that the target cost, that which is sustainable within the employer's budget, is established early on, and then the design is jointly developed by all members of the team so as to bring the project in within the target cost. As I also said before, if the incentive compensation layer is exhausted, if the project is such that it encounters challenges, that are not sustainable within the target cost, then the contractor team loses its profit. That's the element of risk that they accept under the IPD model, and then the owner is obliged to pay the cost of completion without any additional profit, all backed by these broad liability waivers. Now, procurement of IPD projects is a very interesting process because, and without getting into this too deeply, you'll see in some of the subsequent slides where we talk about risks and challenges. One of the concerns around IPD, even in my home country, Canada, where there's been a reasonable uptake of IPD, is that most contractors, most owners, both private and public, most designers are not familiar with IPD. Once you recognize this fact, that the market is immature in this regard, it means that the procurement process for a successful IPD project has to be designed in a way to overcome this lack of knowledge. So on this slide, there's a description of two different RFP-based approaches to establishing an IPD team. But I think it's important to draw to your attention that the RFP moment is preceded in most of these projects in my jurisdiction by an RFQ process where the employer, backstopped by counsel who have significant depth of experience in IPD, will meet with all qualified proponents and go through a socialization process, an education process. And from the employer's perspective, that's necessary not just to educate your bidders, but to be satisfied that the proponents are actually going to commit to the IPD process, to get a sense at a very early stage that the contractor designer team is open-minded to embracing this shift from conventional contracting. And on the projects in my home jurisdiction that have been successful, this has been a very important feature of the procurement process. And these two bullets describe some differing mechanics. I would say that the most significant aspect of these two approaches is that they are both RFP-based. And that's essential for a public owner to be able to bring itself within the policies associated with public procurement.
Just flip to the next slide. Other way, there we go. Thanks, Bruce. Well, clearly, Bruce and I and others feel that collaborative contracting can be very effective on certain types of projects. And there's evidence that it has been successful. There are, however, challenges with collaborative contracting that differ from those with traditional, those one encounters in traditional means of construction contracting. And it is not the right approach for many projects. It's probably not the right approach for most projects. Some of these challenges are noted here, but I want to pick up on something Bruce just said. There's a challenge that isn't reflected in the bullets that bears mentioning. That is that collaborative contracting, when a public procurement entity seeks to pursue it, often conflicts or is seen to conflict with the procurement laws that apply to that public entity, and there have to be steps taken to make sure that the collaborative contracting approach can align with the applicable procurement structure. Bruce just referred to those. But in addition to that challenge, and even if it's a private entity that is doing the procurement in such a project, so some of the difficulties are that, again, as was apparent in Bruce's comments about IPD and the involvement of all the parties to the head contract or the alliance contract and the alliancing structure, it's that every party has to make an early and substantial investment in understanding the project and contributing to the project development, whether it's the development of the target cost, the time, the design, or what have you. So that requires that the participants who are party to this multi-party contract have an understanding for what it is they're getting into firstly, and then have sufficient team of professionals, experienced construction professionals or advisors who can devote the time and effort at a level of sophistication that will help the project be successful. Another of the challenges that is most often mentioned perhaps by employers when they are weighing whether or not to use a collaborative approach is the fact that they don't have, or in their minds, they don't perceive that they have cost certainty when they decide to embark on the project, and they don't. And they don't perceive that they will have cost certainty soon enough to warrant the investment or to warrant someone recommending the investment to others who may be responsible for the purse strings. Now that is, frankly, in my view, a false or often false view. There is the view, often taken by employers, that a hard dollar contract of a traditional nature that shifts most risks to the contractor and so on does give cost certainty, whereas a collaborative approach does not. Well, we as lawyers know that is not always true, and it is often not true, because that price that's printed on the fourth or fifth page of the first section of the contract does not account for litigation risk, tail risk, the costs of unexpected occurrences, and so on. And so one really doesn't have cost certainty in traditional contracting either. And what proponents of collaborative contracting would say is, let's accept that there's no cost certainty from the outset, even in the old ways of doing things. Let's also accept that the owner ultimately bears all the risk, because it's the owner who has to deliver that project at the end of the day and has to cover the costs, whatever they may be. The owner may then have recourse in traditional contracting methods to the head contractor, prime contractor, or others with which it is in privity, but that recourse on large, complex projects may be, frankly, cold comfort when one finds that the liquidated damages to which one may be entitled are woefully insufficient to cover the lost opportunity costs that an owner has suffered, or finds that the contractors with whom the owner has contracted simply don't have the balance sheet to satisfy a judgment or reward that might ultimately come. And so those who do turn to collaborative contracting have typically been through the belly of the whale, if you will, and have decided that this is a better way than the other way, and then they thus have the sophistication to realize the false economies of hard dollar contracting. The other points there are more obvious as far as the pain. When a contract does go wrong or a project does go wrong, and contractors have exhausted their opportunity for a profit, then they can become demotivated. That's a challenge. That's a challenge in any project, not just in a collaborative project. But demotivated contractor without legal liability is an added challenge. And of course, the requirement for consensus management that Bruce has mentioned can cause deadlocks, and the risk or the mitigator to that is the early involvement of very capable professional parties, as I mentioned, who are engaged in an integrity-based trust relationship and who are going to and are willing to depend on each other to deliver.
So we'd like to also touch on the risks associated with the utilization of collaborative contracts. Before doing that, I'd like to add one thought to Tom's comments, and that is another perceived benefit/challenge in regards to these types of contracts is that if they go well, then the thesis is that the contract, that the relationships that are derived from the multilateral contract will inoculate the project against the poisonous relationships which can evolve in circumstances where the contractor has lost and is continuing to lose astonishingly large amounts of money, and the owner, employer, is firmly rejecting the legitimacy of any claim for additional compensation. I'm sure we've all seen projects that have been burdened under this type of poisoned relationship. And so achieving a true collaborative relationship amongst the individuals who are supposed to deliver the project is one of the principal points. But if you fail to achieve that, well, then you're not in Kansas anymore, because the types of disputes that can emerge are not those that we are accustomed to. So council are no longer in Kansas. But the risks that we've called out on this slide are one that I mentioned earlier, is just lack of experience in the market. And even if you have an employer that has developed experience, and a contractor and a designer, the pickings can get slim once you're down into the sub-trade level. It's unlikely, at least in an emerging market like Canada's, that there's going to be a significant number of trade contractors, mechanical contractors, electrical contractors, concrete forming folks, who do have direct experience. That gives rise to the risk of a failure to collaborate. The testosterone-infused, if you don't mind my using that terminology, mechanical contractor signs on without really appreciating the nature of the commitment, and reverts, which is a term that comes up in this context in the writing on the subject, reverts to behaviors that have worked for my hypothetical mechanical subcontractor in the conventional contracting environment, which has a tendency to eliminate transparency and fracture the trust that is essential to consensus. It's a form of defection, if you will. It's also referred to as the toxic party, a person who will not play nicely in the sandbox of collaboration. Next, the planning phase, which we've referred to repeatedly, is essential to the success of the collaborative project, perhaps even to a greater degree than one might encounter in a conventional context, because the planning is not just the planning of the general contractor establishing a schedule or program for the project and a project management plan, and then disseminating that to folks who have to take the contractor's direction. Planning is a consensus building effort, and the more parties you have subscribing to the plan for the project, if it doesn't receive adequate attention, the greater likelihood that someone is going to fall out of the plan. We've both referred to co-location and how important the principle of co-location is considered in this context. If you don't achieve co-location of all the significant players, then you lose a bunch of the benefits that are considered to be derived from effective co-location. You don't get the enhanced communication, you don't get the simplification of project management. There's an expression called over-the-shoulder meetings. So in a co-located environment, theoretically, there are multiple over-the-shoulder meetings taking place at all times, at all levels, which eliminates inefficiencies in management and supercharges creativity. This in turn, again, theoretically, particularly if everyone is signed on to and understands BIM properly, is intended to reduce or eliminate the necessity for rework, which is one of the fundamental objectives of lean contracting. If you don't get all these things, then in turn you have the enhanced risk of reversion to conventional attitudes. Inadequate project controls. When I think about this point, I think about the failure to utilize BIM and other project management applications across the team, where you have a situation where the understanding or the utilization of the methods that have been subscribed to by the team are not taken up by some of the members. Failure to choose the right participants. You know, if we call back my fictional hypothetical testosterone-infused mechanical subcontractor, if you chose my hypothetical mechanical subcontractor, then you've made a bad decision going in by inviting that person to be part of the team. Inadequate validation is insufficient attention paid to the agreement around target cost, and or inadequate attention paid to validating the proposition that the design that emerges out of the design process can actually be delivered within that target cost. And as would be the case in a conventional project, if there's poor management of these issues, then there's the risk that the team will break down and a toxic party will emerge. If a toxic party emerges, then the writing on the subject indicates that it's essential to terminate that person very promptly and with extreme prejudice.
So thank you, Bruce. And what we've done now is on these next two slides, which feel free to photograph if you like, or I imagine the quarter of the Academy might be able to distribute them to those who want them. But we've listed just some standard form contracts that might be of interest to those who want to look further at this form of contracting. There are IPD standard forms listed, most of those from North America, and then some alliance contract standard forms. The overarching concepts between IPD and alliancing, in my view, are the same. There are differences in approach that have arisen from the fact that these types of contracting have grown up rather contemporaneously in different parts of the world. But the alliance forms are from Australia and the UK. And then, next slide. Yeah. And then also some further reading that is available or to which you can turn if you like.
Yeah, just one final comment, and that is in terms of selected reading, it's worth mentioning that Howard Ashcraft, who is the author of the paper that's referred to in the first bullet on this slide, is perhaps one of the two folks in Europe and North America who have really given very careful consideration over an extended period of time to collaborative contracting, and in Howard's case, IPD in particular. I commend Howard Ashcraft's writing to you. The second person who has a very deep understanding of this subject is Arndt van Wassenaar, who is with us in the audience today and is one of the fellows of the International Academy of Construction Law. So that was my final comment, Lawrence. Thank you.
Thank you very much.
Thank you, thank you. In a very quick sum up of the entire international experience, collaborative and constructing, major challenge, but I'm glad you did that. So we are moving from the content to a nice discussion. I'd just like to bring up our president of the Singapore International Commercial Court, Justice Philip Jeyaretnam. Thank you. Okay, no introduction required, Judge. And next, our other judge from the Singapore International Commercial Court, but our international judge, Sir Vivian Ramsey. Can, in the interest of time, panelists, if you forgive me, I will just ask them to read the rest of it. And then from Nagashima owner in Tsunematsu, a partner there, Mr. Naoki Iguchi, Iguchi-san, and the founding partner of Pinson Masons M. Pillay, Mr. Mohan R. Pillay himself. Ladies and gentlemen, could I just ask you to please give a very warm welcome to the panel, and I will just leave it to Justice Jeyaretnam to handle this.
Thank you, Lawrence. Is this on? Is this on? Yeah. Okay, great. Wonderful. Let me start just by explaining why collaborative contracting this afternoon. Why have we put this forward? You know, after all, SICC, aren't we all about disputes? And doesn't it sound like collaborative contracting is going to reduce the number of disputes, and that can't be good for lawyers, let alone for court systems? Well, of course, as the Singapore police say, low crime doesn't mean no crime, and few disputes doesn't mean no disputes, right? So the topic is important because it is responding to the needs of the industry. It's a theme which our own Building and Construction Authority has been working on, has been influencing the industry to move towards. And as some of you know, I know that there are certainly people from contractors. I think there's someone from BCA as well here today. So it is very much the topic of the day as a way to achieve a more effective, more efficient project delivery and save time and costs in the interests of everyone. And of course, that's ultimately what the SICC is all about too anyway. So with that, and thanking, of course, Bruce and Tom for that excellent introduction, I'd like to kick off by turning to the other three panelists just for a quick response, drawing on their own experience, either personal experience or the experience of their jurisdictions, on this topic of collaborative contracting. And if I could perhaps ask Sir Vivian Ramsey to start first.
Thank you. I think one of the important things to come out of this is that what we've seen in IPD is really the top of the tree in terms of collaboration. And those of you, I'm sure there are a number here who have seen the NEC form, was in a sense the first step in trying to move away from traditional contract forms into something which was more of a management tool which allowed the project to be a success. And I think this, as many of you will know, the NEC has that wonderful spirit of mutual trust and cooperation as one of the strap lines in the contract. Now, that is all well and good, but when you get a dispute, not many people say that clause 10.1 of the NEC is what you should be bringing your cause of action about. And therefore, one needs to look, I think, at new ways of producing that collaboration as we move away in the spectrum from traditional contracting to ones where really the project is the important part of the endeavor, rather than looking at individual silos for each of the team members. And IPD is really what everybody should be trying to achieve, but as has been said, it's not really completely achievable yet on every project. And if I can just say three things about the things you need for it. The first is you need a client who has potentially deep pockets. It's cost reimbursable, and therefore you need a client who is in the position where the project is key to that client. So in other words, money is not the chief
driver of that project. And the second thing you need is not only experienced, but I think the word has been used, non-toxic members of the team. In other words, you need people who are really bought in to the whole concept and will work 24 hours a day to make sure that project is a success. And within the construction industry, I have to say that is quite a big ask to get that commitment to the project. But those are two of the things. And then the third is you need the right project. This won't work for every project, but for instance, if you want a particular factory for a technology which needs to be produced very quickly, for instance, it may be a chip factory. If you really need that quickly, then the client and the whole team will be behind getting that there. So I think you need the right client, you need the right team, and you need the right project. But if you have that, what I would suggest is we should move up to the top of that tree, and even if we don't achieve the top of that tree, we should be looking to climb up it over the next few years.
Thank you. That's actually quite an inspiring vision. But Naoki, can I turn to you now?
Thank you. Well, just allow me to touch on my background, why I'm here as one of the panel members. So, I am basically based in Tokyo as a Japanese lawyer, but more than half of my work portfolio is international, overseas construction related. So I frequently come to Singapore to actually collaborate with the Singapore lawyers, law firms, for negotiation of the transaction or arbitration for the project in this, particularly in the Southeast Asia region. When I go back to Japan, my home jurisdiction, collaboration is always the #1 thesis for the project. So if one refers to collaboration, no one can make any rebuttal to it. But the reality of many of the construction contracts particularly in domestic construction contracts in civil law jurisdiction, particularly in, well, to my experience, Japan, South Korea, Taiwan, or partly in China, still really lacks a detailed provision for risk allocation, even in a big project, and simply saying the collaboration between the employer and contractor, or the collaboration between the contractor and other contractor at the site. So many, even the business people and lawyers in my home jurisdiction, sadly misunderstand that collaboration simply means just to do not put many detailed risk allocation provisions in the contract, because that may prolong the negotiation phase, and just to put two general collaboration provisions in the contract. And the court may interpret that abstract provisions and withdraw many, and lead many conclusions or minor rules on particularly applicable to that project. So that practice is not, in my opinion, not the matured collaboration contracting. Collaboration contracting, in my understanding, needs contract provisions which facilitate or enable the collaboration between the parties in the project. Well, we have already discussed, and thanks to Bruce and Tom, that we have already heard the most important issues for drafting or making delivery of the project under that contract for the collaborative contract or collaborative project. We civil law jurisdictions are really much interested in how Singapore will develop this collaborative contracting in your form based on the common law practice and knowledge that could be or might be introduced to our jurisdictions in Northern Asian regions. So for that purpose, in my view, that Singapore may be able to realize it, supported by a sufficient number of professionals in legal community and engineering professionals. These are the key factors to actually enable or perform the collaborating contractor provisions that you are now pursuing to draft up or more better provisions for that collaborative contracting. So we really looking forward to have the Singapore's experience and the Singapore outcome in the near future. Thank you.
Thank you, Naoki. That's a really good point, that actually it entails more planning, not less planning, and it's just that that planning is to take place across the table in a collaborative fashion. And you've flagged what you hope to see from the Singapore experience. So with that, let me turn to Mohan.
Thank you, Philip. I thought I'd try and localize this a little bit in terms of where we are here in Singapore. And I thought I'd take it in three brief phases. One is to try and just draw together the strands of what we've heard from Bruce and Tom in terms of the sort of philosophical underpinnings of collaborative contract. Secondly, the extent to which we find those kinds of features here in our contract forms. And finally, conclude with some observations about what it is that we are beginning to do about the state of play. So touching on the first point, as you will already have gleaned from the presentation, the entire philosophical focus around collaborative contract is problem solving in a way that benefits not just the project, but the interests of everyone across the project, as opposed to fault finding and blaming someone else. And some of the trappings of how that is introduced into the contract, as you've heard, would involve elements like having key performance indicators around which you share problems in terms of the financial impact or share the profits that come out of resolving or achieving those key performance indicators, early warnings on anything that might adversely affect the project, and having workshops around how to manage all of that. And finally, broad no liability agreements, safe for willful, sort of wanton breaches of contract. Now, the extent to which those kinds of features are common in the forms of contract that are prevalent with what most of us in this room are used to is that you don't really find those features in most of our standard form contracts. Our standard form contracts are by and large rights-based, and to borrow a phrase from the Chief Justice in a speech that he gave recently and which has since been published, very fault-centric. So that's where we are, and that brings me to the third point about what it is that we are seeking to do about that state of play. And I think clearly here we are beginning to see a level of traction and appeal in terms of some of the evident and obvious benefits in terms of collaborative contracting. There's been an excellent guide that has been prepared by the Academy, a guide on collaborative contracting in the construction industry, and I'm happy to tout it without embarrassment or blushing because I had absolutely nothing to do with it. But there are a number of you in the room that did, so it's an excellent guide and certainly something that I would encourage you to take a look at. Secondly, we are beginning to see a considerable lead from the front with the introduction of option module E for the public service sector conditions of contract, which provides a number of provisions that you will recognize. It recognizes and obliges the parties to use best endeavors to work in a spirit of mutual trust and cooperation. It provides for early warning. It has introduced a provision that some of us may be familiar with, which is the Singapore Infrastructure Dispute Management Protocol, which provides a wide breadth of and this is key, managing the disputes. And it's not just about resolving, it's about managing it so that you can try and avoid full-blown problems, right from mediation, right through to determination. So I think that we are beginning to see some amount of traction. There is a clear commitment, I think, from the front by the government agencies, and the government, of course, lets an enormous amount of our infrastructure projects. And we're beginning to see a lead from the front in terms of introducing this. And this form of contract with option module E is already in use on the Punggol Digital project. So we're already beginning to see that. And I think that is, I hope, for many of us who believe in the future of collaborative contracting, the start of what is going to be a potential shift in the way we take a look at what is the right way to manage a project that benefits everyone, rather than just finger pointing, which has been the conventional approach to our projects.
Thanks, Mohan. Mohan ended with the example of the option E, the module E of the PSSOC. It is significant, of course, that the public sector in Singapore is taking the lead on this. But I wanted to, from there, really ask you, Bruce, you did touch on this problem about procurement and public, in particular in a public sector context. And I suppose that, the challenges include that before you can actually get to a price, you have to have quite a bit of discussion about how this collaboration is going to work, where the risks are going to lie, or how they're going to be shared and managed, perhaps, rather than where they're going to be allocated. Could you just elaborate a little bit on how the public sector in Canada navigated this path?
Certainly, certainly. And it is a point that's really fundamental to the success of IPD in Canada. So a few contextual points. Alliancing was initially embraced in what we refer to as the oil patch of Alberta. So when you think about owners with deep pockets, whose fundamental objective is to achieve the deliverable, because the deliverable is going to generate revenues that really dwarf the cost of construction over time, large oil cos probably would be fairly close to the head of that list. So in the early going in Canada, there was a reasonable uptake of the alliancing model by oil cos in the Alberta oil patch, which set the foundation for the introduction of IPD. IPD, in turn, was promoted in Canada very effectively by Howard Ashcraft. Howard, who is, for anyone who's met him, is certainly a very impressive and expert lawyer in all aspects of construction, made it a point to visit Canada repeatedly, providing educational presentations and briefings and meeting with contractors and meeting with government authorities, and enjoyed some early successes, interestingly, in the private sector, but was then able to point to those successes, which were achieved with a particular contractor from Western Canada who took up the cause of IPD and made it a fundamental touchstone of their business, a company called Chandos Construction. So these early successes and these early educational efforts obtained very good traction, and the public sector players began to be very interested. So I'm now circling back to your question, Philip. Each of our provinces and many of our major municipalities and of course our federal government as well. But perhaps more to the point, each of the provinces and major municipalities, of course, have procurement policies. And those procurement policies are, again, drafted along a spectrum. Some of them are very constraining and only permit public procurement to take place on the basis of hard bid competitions. Others are more forgiving. The introduction of the use of RFPs into the Canadian public sector market about 20, 25 years ago caused most of these procurement policies to be broadened out because municipalities and provincial governments saw the potential benefits of the RFP approach to procurement. And once the infrastructure renewal programs that have been running in Canada for about the last 20 years or so really began to get traction, of course, it was necessary to broaden these procurement policies to permit PPP to be utilized to deliver these large infrastructure projects. So by happy, perhaps somewhat random circumstance, the broadening of these procurement policies left an opening for public sector employers to adopt IPD. And that's why we see IPD typically being taken up in these public procurements by way of RFP. The procurement policies broadened to permit the RFP approach, and now the IPD projects are emerging through those broadened policies. There are still some policies at the municipal level that haven't caught up, but mostly the landscape is reasonably forgiving. I would commend to you a report that was issued in May 2022 by the IPD Alliance of Canada, the University of British Columbia, and the École des Ingénieurs Supérieurs. So it's a 3-author report on the success of IPD in Canada. And it delves very deeply into 3 projects, all public sector projects. And it's quite a remarkable report because it breaks down the process of developing an IPD project from a public sector owner's perspective to a very fine iterative level, and then shows the reader how each of these 3 projects either conformed to or deviated from best practices in regards to that step-by-step approach to success. So it's a very good description of multiple factors that have contributed to the success of public sector IPD projects in Canada. Very well written, and I think quite informative, stacks up quite well against some of Howard Ashcraft's writing.
Thank you, Bruce. I'm going to open it up to the floor, including to some of our fellows who have not had the opportunity to be on the panel, but of course who have a great deal of experience and may have valuable comments to offer. But I'll just ask one more question first to give you a bit of time to think of questions to put forward. And I thought it might be helpful just to address one issue, which is perhaps, the unfamiliarity of lawyers and indeed courts of dealing with some of these softer terms which are introduced into collaborative contracts. Express terms of mutual trust and cooperation, for example, or duties of cooperation generally, or duties of good faith. We're, I think, mostly familiar, certainly as common lawyers, with the prevention principle and how that works. But these are difficult, unfamiliar. So, I thought that this might be something we should just explore a little bit. And perhaps if I could just invite Vivian to start, and then maybe just go down the line.
Yeah. Well, I think, as we've indicated, this is a completely new way of doing things once you go into collaborative contracting. And the problem, I think, is that in most legal systems, the law requires clear, well-defined certainty about the terms. And what you are not going to get in terms of collaborative contracting is those very clear, laid down responsibilities which we all know and love when you're looking for breaches. And therefore, I think you've got to have a completely different view of how you police these types of contract. And one thing is I think you have to have embedded probably a lawyer within the team who can, or a mediator, somebody with the qualities that can deal with woolly-edged obligations. And I think unless you have that, and it's got to be, again, a non-toxic member of the team who is really trying as much as they can to avoid any disputes. And we know that dispute avoidance works. And this, I think, is a classic case where you move towards it, you need to have something to avoid those disputes.
Thank you.
In response to Philip's question, so surprisingly, it is really common in the civil law contract where the term mutual trust or a good faith, those terms are used. Well, I believe that not only in construction, but also in every business industry, the contract contains such words in the contract. But it still doesn't provide a solution because the delineation of or definition of these terms are not that clear, so that could be used to make some adjustment when the court considers project and interprets the contract in this way. So I will send the civil law jurisdiction business people or the lawyers under the alert that even though we have already used the word mutual trust, we are not using the collaborating contract in the modern sense.
Thank you. The principle of prevention calls out a very interesting legal issue in relation to collaborative contracting. In a conventional construction contract, the deal is that the owner hires the contractor, and the contractor agrees to deliver whatever it happens to be. I like to refer to it as the deliverable, whether it's a building or an LRT or a factory, and the owner agrees to pay. So when we think about prevention, it's the owner preventing the contractor from performing its obligation to provide the deliverable. That is a bilateral relationship. Once you have a multilateral relationship, however, you have lost the commitment on the part of the contractor to deliver to the owner, which is a very simple concept, and prevention can apply quite easily. And you have an agreement between a large number of people, multilateral commitments to produce the deliverable. So the owner is actually committed to all the other parties to do whatever it needs to do to deliver the deliverable to itself. So in a multilateral environment, and the reason that this came home to our firm is that we act for the regional transit authority of the government of Ontario, an entity known as Metrolinx, which is in the midst of a $50 billion infrastructure renewal program. And Metrolinx is very interested in IPD. And they're doing a sizable project on IPD. And where this emerged was when we began looking at the performance security issue. So when you think about performance security in the conventional environment, it's a surety bond or a letter of credit which guarantees that the contractor will deliver the project to the owner. But once you're in a multilateral environment, you don't even have the principle of joint and several liability to resort to in a clear fashion, because the owner can't be obligated to itself to deliver the project. And so it has produced some very interesting drafting challenges. But when we think about Philip's question, who is preventing who? Those behaviors that are easily susceptible to analysis in the conventional structure suddenly become much more challenging. So I think it's a very, very important question, and one that, at least in our office, we're still grappling with.
If I could, thank you. If you permit me a moment of philosophy, it's my view that for lawyers advising on projects that are delivered through a collaborative contract, and because of the fact that, at least in pure collaborative contracting, most all rights of litigation, as Bruce mentioned earlier, are waived, that it's important to be able to lift yourself out of a traditional legal framework-based analysis of the contract. It's not a rights-based contract in the way that we're familiar with. It's not. I was reared as a construction lawyer to allocate risk in the contract, allocate all risks you can imagine, and if you're altruistic, allocate risks to the party who's best able to control it. But frankly, if you're acting for your client, try to push all the risk to the other party, right? That doesn't happen, or it shouldn't happen in the collaborative structure. Risks are shared, all of them. And so traditional rules of contract and rules of law, you likely won't be able to apply in any event, not in the circumstance where you go to court and litigate over a breach or a failure. But they're nonetheless quite useful, and lawyers, as Vivian mentioned earlier, are quite useful to all the participants in the project. Firstly, because it's important to advise your clients as to the differences they're encountering in a collaborative contract versus in their in the environments with which they may be more familiar. Secondly, drafting skill is key. These contracts are, and the documents related to them are often quite voluminous, because the goal, of course, is to set out as clearly and plainly as possible a structure not just for the contract, but for the delivery of the project. And we've all encountered circumstances where those sorts of structures are woefully ill-drafted. So strong drafting at an early stage to assure that all the parties really understand what they're engaged in is of great importance. And thirdly, lawyers who are good dispute resolvers, either because they have learned enough from failures in litigation that they understand the importance of settling cases, or because they've been trained as mediators, or they just have a flair for it, are quite useful in these projects. Because the same claims and disputes that arise on other projects also arise on collaborative projects. They just have to be resolved within the project, ideally immediately or in real time. So strong dispute resolution skills, strong negotiation skills, strong mediation skills are quite useful as well. And of course, legal concepts are useful in that process, but won't determine that resolution.
Thank you. I wanted to just make three brief points. First, on the point of the act of prevention and the relevance of that to the subject matter that we're talking about. Second, about the difficulty that Philip has quite rightly referred to when dealing with concepts such as good faith in the common law world. And third, a clause that you do find in collaborative contracts that might assist in that process. So, you know, dealing first with the act of prevention, I mean, that is something that is well known to common law lawyers who might not recognize a collaborative contract if one walked past us in the street, because it is a very clear provision. And in some respects, you know, when you think about it in the context of collaborative contract, you might possibly persuade yourself that it is at a very base level, at a very elementary level, a reflection of the obligation to act in a way that collaborates by not interfering. It is a negative duty. Of course, under the common law, it arises and is premised on the concept that a party can't take advantage of your own wrong. And in some respects, you know, you might see that as, well, that is a bit of an expression of a duty of good faith, because that is what would be expected of you when you enter into a contract, that in good faith you can't be setting up obstacles, preventing somebody else from discharging the obligation, and then holding that party to account for something that you were responsible for. So in some respects there is, albeit I concede, a potentially tenuous link to the subject matter at hand. My second point about good faith, and of course the common law world has tried to grapple with how best to deal with these sorts of concepts. It's probably worth reminding ourselves that some major systems of the world have recognized and enforced this provision as a basic underlying element of their legal system. In the civil law, this obligation is entrenched, it's well recognized, it's enforced. And it is possibly an area from which we can glean some lessons by taking a look at how civil law countries have dealt with something as fundamental as good faith in their system of law. And the third point I would make in the context of how to deal with policing these kinds of obligations is that one of the key elements you find in collaborative contracting is, of course, the no liability waiver. The exception to that, which is very often found in collaborative contract, that is carved out, is that you will be liable for willful breach. And I would suggest that as you go into collaborative contracting, you will end up having to focus quite a lot on trying to distinguish breaches that are no longer actionable because of this broad waiver, and which would therefore generally fall within the concept of good faith, and willful, and in some cases, some provisions will say willful and wanton breaches, which will clearly take it out of that kind of context. And therefore, there may be growing emphasis when we're dealing with these kind of contracts at trying to understand, define, and scope that provision, because it makes it actionable, it takes it out, and therefore says this is the one thing we will not tolerate. Everything else is not actionable, and therefore you've got a scope within which parties will be very, very careful about avoiding, and therefore focus staying out of that and then working with everybody else around the obligations. And I think the result of that will be more and more focus will come across that is a provision that you will find in some exception, some exclusion clauses in a number of contracts, but I think it will become of growing importance as a result of the centrality of that kind of provision in collaborative contracts.
Well, I think at this point, let me just invite, yes, Ratan. I think is there anyone with a mic? Do you have a mic somewhere? Or, yeah.
May I have quick comments from Bruce and Tom on, as there is a unanimity in the panel that the lack of awareness about this collaborative contracting in many jurisdictions is a challenge. Apart from training them, apart from what Tom says, that you should have a proper documentation for collaborative contracting. Somehow my sense is that administration of those clauses for collaborative contracting during the stage of execution of the contract is the key. Why cannot one think of a independent consulting agency, loosely if we can relate with the independent engineer, why can't they be made part of, their role be made part of the contract itself from beginning, so that they can really help the parties? Howsoever better written, you may have a fantastic lawyer writing all of this. Parties should understand what this means. So why can't we think of role of experienced independent consulting agency during this, for this kind of project?
Well, thanks, Ratan, for the question. It's a good question. In the Australian history of alliance and contracting, at least, there is a role called the alliance manager, which is a role that can be filled, and my understanding is filled occasionally by consultants, consulting engineers, project management types, and so on. And that's a necessary role, and you're right, to identify the substantial administrative burden that falls on the parties in these projects. The caution, I would say, is that parties, particularly an owner, cannot feel that, well, I've got a manager, so I can absent myself from the process. We all know, or probably have seen projects, collaborative or not, where an employer steps back and allows a hired construction manager to run the project, which without employer management and intervention, and at least in my experience, that often goes wrong.
I think it's a great question because it touches on really the three legs of the stool. So education, proper forms of contracts, and assistance with management. In Canada, the infrastructure renewal program to which I referred is national. It's happening at the federal level, but in every province. We have 10 provinces, 2 territories in Canada. This infrastructure renewal program has been going on for more than 20 years. After the announcement of this program, each of the provinces, beginning with the province of Ontario and followed by British Columbia and then Quebec and so on, created agencies of the provincial governments for exactly this purpose. The agency in Ontario is called Infrastructure Ontario, and in BC it's Partnerships BC. But their role is exactly as you've described. They educate public sector employers who are going into the infrastructure renewal market. They provide standard form contracts, and then they shepherd the project forward, assisting somewhat unsophisticated frontline ministries and broader public sector entities to get the project right. And Infrastructure Ontario has a very active role in doing exactly this for IPD at the current time. So yes, there is a role for such agencies, and in Canada at least, these provincial agencies have been remarkably successful.
Arend.
Thank you very much, Philip. And thank you very much, members of the panel, for your wonderful presentations and observations. But we have heard from you that these collaborative contracts are filled with clauses which are non-enforceable, which talk about mutual trust and cooperation, which include new experts such as alliance managers, project supervisors. There's early warning for which you have to work together, whereas typically this would be a contractor's issue, I would say, in normal contracts. Planning, scheduling, so there's lots of stuff to be done. So can one of you or two of you give the audience a 1 or 2 minute elevator pitch of why, despite all these issues, they should go for collaborative contracting and advise their clients what's the benefit of it, because that's something which I believe is of real importance. And the second question, if time permits, is collaborative contracting requires, as you told us, a lot of collaboration. And collaboration is not something you can write down in the contract, thou shall collaborate or something. It's behavior, and it's based on trust, and based on those sort of things. So what would you recommend to the parties implementing these either or not collaborative contracts or just collaboration to make sure that that behavior will be the spirit of their mutual cooperation?
I have the feeling that you know the answer to this question, Art. It just so happens that in preparing for today's presentation, I had occasion to go back and read some of the publications of Howard Ashcraft, who I keep referring to because he's such a remarkable student of this subject. And he has a paper which answers your question, and the answer is that the project will be delivered with less delay and at a lower price than the same class of project delivered by way of conventional methods. So hopefully that was a short enough answer for you.
Thank you.
Sorry, Aaron, can I just make a point? You know, I think you adopt the rule of most cross-examiners, never ask a question to which you don't know the answer. But I thought, you know, in terms of the pitch, there are 2 points that I would make in terms of this. One is that for the contractor, this particular approach to contracting means more shared risk. It means he reduces his exposure. That's a benefit to the contractor. The benefit to the employer is when he shares in the risk, he's more likely to get a competitive price for the project because the contractor is taking much less risk. And these two benefits, if it's captured properly in the way in which that contract is structured on a commercial level, is bound to be of appeal to both of these parties, one would think. And ultimately, I think you do need to appeal to the parties at a commercial level. None of this legal structuring is going to be of any appeal whatsoever unless commercially they can justify this to their board and to their shareholders. But I think there are some commercial benefits that come out of this in terms of a reduction in risk and a reduction in the delivery price of the project.
Just a quick addition to that. For those who are advising contractors who might be considering this type of approach or being drawn into it because employers want, as Bruce said, their projects delivered more likely on budget and more likely on time, the quid pro quo to the contractor is these are cost reimbursable projects. So, and typically the contractor share of the pain share, as we referred to it, is capped. It's or limited to the contractor's profit, and in some cases a share of overheads that the contractor might otherwise receive. But the costs are going to be guaranteed. Contractors don't have that in hard dollar contracting. If a project goes completely pear-shaped, the contractor can be on the hook for up to the liability limit, which might be the value of the contract. So that is a substantial consideration for a contract.
Are there any last questions from the audience?
The second question was
I guess that in itself is an answer. Sorry, was there anyone else? Ah, Jaime, sorry, I didn't see you.
Thank you. I would like to share an experience, the Peruvian experience, of course. And your presentations were very clear, and I share what has been said here. However, in my experience, the real challenge is cultural. That's the key issue, okay? It's not only, the challenge is not only to read together the contract, to co-locate and work together. The challenge is to stop distrusting my counterparty. That's the challenge. And in my country, that was almost impossible until a consultant came and a PMO came and explained that it was necessary to share personal stories, to show the photo of your grandson, and things like that, and having lunch together, and then start taking decisions together. And that's a key issue that I just like to share. That's it. Thank you.
Thank you. That's a really valuable comment. I think we should bring these proceedings? Oh, okay, there is a question over here, yes?
Well, actually not a question, so just one comment.
Yes.
Thanks, Judge Jeyaretnam. I'm from BCA. I'm the Deputy CEO at BCA, and I probably know a few of you guys over here. Just wanted to make a comment that, well, number one, I'm really pleased that there is this effort today to us within the EXCO as well in BCA and to the entire organization. We do believe that collaborative contracting is absolutely important. It is the way to go. We have to move quickly because the conditions of the sector today are just not commercially sustainable in the long run. And to me personally, I believe that collaborative contracting is the single thing that we need to move first, because everything starts from procurement. All the ills that we see in the industry today, all the conflicts, the inefficiencies as well because of conflicts, because of distrust, etc., really starts from collaborative contracting. So my just one appeal to everybody is that I think we do recognize that our sector is in Singapore. I hope I share the optimism where we get to move quickly, move first, but then it is challenging in Singapore. A lot of projects, I think, do not necessarily have all the ingredients. So my appeal to everybody is that if you see any of your projects where you feel that the ingredients are almost there, right? The top management perhaps could be nudged, perhaps people can be trained. You feel that there are more or less, kind of the A-team folks from the project parties who are involved in the project. Let me know. I'll hang around. All right, we do want to find as many projects as possible to get started. It will be a happy problem if right after this we have many projects and then there's a worry that we have to think about how to train everybody and execute the projects properly. That will be a happy problem. Yeah, we'll get there when we get there, but essentially, yes, we would want to move quickly. So I'll hang around, I'll give you my cards, otherwise you can find me online, all right, SGDI. Thank you.
Thank you. So the message there is, of course, that we must all collaborate in this transformation of the industry towards collaborative contracting. And I do believe, as you have suggested, that the legal profession can play a very important part in that. So just before we conclude, I thought I'd just invite Vivian, if you would like to just say a few words by way of wrap, and then we'll close the session, and there'll be drinks afterwards.
Well, that's always a challenge when you stand between the drinks and the audience. I think let's just look at a few principles which we've considered this afternoon. I think everybody here would agree that the old model of contracting, where people act in their silos, they look after their self-interest, don't really trust anybody else who they're dealing with because they know they would like to get a better deal out of them, where therefore projects overrun and cost more, and very often the person who bears the cost is that person who is least able to bear the cost within the project, is a dead model. Now, if you adopt that attitude, I think one has to say, how then do we move to what we've heard this afternoon as really the top of the tree, as I've described it, of IPD? And I think, as Jaime said, it's a matter of culture, changing the attitude, and people in contracting, employers, and the professions having training so that they adhere to the principles, dare I say it, even if they're not doing an IPD, so that one has this mutual trust between the parties. Certainly in the UK, we found with the Latham report, which really said we can no longer have a toxic contracting industry. It has been a sea change of attitude. And my own view is that one of the problems we have is the lawyers, because the lawyers, of course we're all construction lawyers, but one of the problems is that one looks for hard solutions which don't really match the type of endeavor where you're trying to get a project delivered. You clearly need some, can I put it, boundaries between parties. But I think what one has with integrated project delivery is actually every party cooperating fully and not looking to where the boundary is of what they're doing. And that causes lawyers to shiver. And that's why I suggest that you do need somebody within the project who helps get it over the line where you can't really have anything else. My concern, I have to say, is where you hear that there is an ability to sue another party for willful default. I think all of those here who have seen liability caps in contract will know how often people immediately go to the willful default. I think my own view is that if you waive liability, you waive liability, and if you've got a proper IPD model, you will never get willful default, and therefore you should not even have that within it. But I think if we come back here in 5 years' time and every project in Singapore is being carried out on an IPD model, I won't be surprised. Thank you very much.
Thank you. Thank you. Never mind. Thanks. Thank you, ladies and gentlemen, and for a wonderful session this evening. Just as a concluding part, can I just ask Justice Jeyaretnam to present a small token of appreciation to our panelists? It in no way reflects the amount of time that they've put, especially to spend time in sharing their experience, as well as to Tom and Bruce for putting together the whole content on collaborative contracting. And ladies and gentlemen, could I ask you once more to join me in giving a very warm thank you to the panel. And for your time, and as Sir Vivian said earlier, I'm not going to stand between you and some drinks and canopies at the back. And as the Deputy CEO of BCA has volunteered, you may corner him and ask him, but remember that he will ask for your commitment for collaborative contracting at the same time. Thank you, ladies and gentlemen, for spending time with us on this wonderful evening. Yeah.